Hello, everyone, and welcome to In-House Counsel Insights, which brings together in-house counsel from different companies, different industries, different practices in order to share their tips and experiences with you. Today, I have Brent Dyer, Director, Legal Operations, Employment Law, and Litigation at Trend Micro. Hey, Brent, how are you?
I'm good, Chris.
Good. Thanks for joining me. So we connected on LinkedIn after, I think it was a Brent's post, or I think he posted, and I commented.
Oh, it was me for sure. Yeah.
That he did on first year associate comp, which is, the favorite above the law topic on what first year associates are making according to the, Cravath scale. I came from BigLaw. I was never on Cravath, but, somewhere near the top, probably 75, 80%. When I started my practice in 2008, and it was in a second tier market, it was in Orlando, I was making 100 at a big firm. And then when I went to Houston, it was 140. I think top of the top Cravath back then was 160 in the Houston and Dallas markets. Brent, by the way, is in Dallas. Now it's 225 in those top markets. So Brent, what do you think about that?
Well, so look, firms can pay what they want. And I've had some conversations because of that post. I had some conversations with some big firm lawyers who were like, "Hey, we can pay what we want," and I don't dispute that. Pay what you want. First of all, as a client, my perspective is you can pay what you want, but that doesn't mean that you have the right to make me front that cost, right? If you think you need to pay that, okay, that's what you're going to have to pay. But to say that, hey, Brent, starting salaries just went up 20%. All the rates for associates are going up 20% too. It's like, no, guess what? I'm smart enough to know that there's a lot of flexibility that you have built into the way you do your business. And I'm sorry that you felt you needed to raise rates by starting salaries by 20%, but that doesn't mean my rate should go up by 20%. But the other thing is, I think this ultimately is not going to be sustainable for law firms, although it has been going on for a long time. But they can't continue to pay more money to these associates, higher and higher rates, starting salaries to the new associates, and continue to be able to, I hope, and that's one of the things one of my missions in life is to do this, but continue to be able to compete in the market. We as clients need to start saying, look, that's not sustainable. We're not going to foot the bill for that. And either you need to come up with a better solution or we're going to take our work elsewhere.
Right. Okay. So curious, and I've heard a few things from a few in-house attorneys, what rate for a first-year associate right out of law school supports a 225 base?
I would say based on the firms that I've seen bills for, the rates that they're proposing for 225 base are somewhere between $680 and $890 an hour. And probably closer to the 890 an hour than the 680. But yeah, I've seen lots of starting rates for new associates in the 700, 750 range.
Yeah. And you mentioned something really interesting. And it was one of the things I'm not going to lie, I was pretty proud that I decided to become a lawyer because I was like, man, right out of law school, I can make really good money. These doctors, they get screwed. They don't make any money for a couple years, right?
Right.
Should maybe the system be more like doctors, where you start off a little lower until you get to this level and then it dramatically jumps up? Do you have any thoughts on something like that?
Well, so first of all, I used to represent a lot of doctors, and I can tell you one thing I say all the time: never believe a doctor when they tell you how much they make, because they are consistently lowballing what they make. But no, it's the thing the problem that this creates for me as a client, and I think for law firms too, is that if you're billing your associate, I'll just pick a middle of the road number, but a realistic one. If you're billing your new associate at $750 an hour, I, as the client, there's not much they can do that I'll pay for. Right. I'm not going to pay $750 an hour for your associate to learn and read about basic legal stuff. I'm not going to pay $750 an hour for your associate to figure out things like, how do I calculate the filing deadlines within the Northern District of Texas? Or what are the briefing requirements for the Fifth Circuit? I'm not going to pay for that because $750 an hour is way too much for me to pay for that. And so it creates this problem where it's like, you're sending me a bill for stuff and I'm just saying I'm not paying it. And frankly, it creates problems with the attorney-client relationship, because, the firms are mad at me. Well, what am I supposed to do? And I'm like, it's not my problem. I didn't choose to have this starting salary for your associates that causes you to think you need to push this high rate. It's not my problem. You need to come up with your own solution, but I'm not going to pay for it. And one of the things when I first started out, I can't remember. It was a while ago. You might be able to tell, but it's when I first started out. I was at a AmLaw 200 firm, but it was pretty high up in the AmLaw 200. And we were definitely competitive in terms of what compensation in the area was. But my starting rate, I think it was 150. I can't be sure. It was either 125 or 150. I don't remember what my starting rate was.
150 an hour.
Yes, an hour, my hourly rate.
Yeah.
But one of the things that meant was that, that I could do some of that lower level work and it wasn't going to kill the clients.
Right.
And the other thing it meant was that we could pick up some, and the firm did pick up some really, really small clients and give them a lower rate. So there was a client that I billed quite a bit at $100 an hour, which, that's not a huge drop down, but it did make me very affordable for those smaller clients. And it allowed me to do real substantive work for them and really learn how to do things. But you can't do that now. I mean, what do you do? Do you take your $750 an hour associate and say, I'm going to bill you at $690 an hour? Well, that still doesn't make it affordable for smaller clients.
So when you started out, when did you go to trial? And did your firms, were they okay just throwing you at trial at those $100 rates?
I'm trying to think. So I didn't actually try any cases at my first. No, that's not true. I tried a couple small claims cases at my first firm. It's small claims, low stakes, but a good opportunity to learn. Small claims judges aren't big on evidence or procedure, but they are pretty. They're very keyed in on presentation of evidence. The facts are really important to them, and you can see good small claims court judges. They are watching the facts. I think often they're more sensitive to some very subtle factual issues, much more than just regular trial court judges. So it's a good way to learn, this is how you present facts in a way that makes sense, that are appealing, that create a narrative that's understandable. So I did do some of that, but the first time I actually tried my first jury trial, I had been practicing for 7 years.
Oh, okay.
But up in Collin County, I was first chair. I chose the jury. I made the opening argument. I made the closing. But that was, not terribly soon in my career, but I did a lot of other stuff. I did some appellate work before that, appellate argument in cases. I was allowed to do closing arguments, I think, in a couple of trials before that. I second chaired 2 or 3 trials before I did my first chair trial. It was all good experience and stuff that I think young associates don't really get a chance to do much anymore, especially at big firms.
And that's what I was leading into. So when you're charging, $600 to $800 an hour, are you seeing that? Are you okay with an associate going to trial? Is that still a high rate, or is it more the experience level, or is it a combination of the two?
Well, so first of all, we're talking about BigLaw. I don't know that BigLaw goes to trial. I really don't. Okay. And I have a lot of, I would say, I guess, not healthy hobbies. And one of my not healthy hobbies is I love to look up the bios of the lawyers that show up on my bills. And one of the things I've noticed is I'm not even associates. I will look at, partners who've been practicing for almost as many years as I have, sometimes more years than I have. And these are litigation partners, and they have not a single trial on their representative experience, not a single one. And I'm like, why am I paying you anything? And how much can I trust? Like when I ask you, what's our risk in this case? How do I even know? How do you know that? You've never stood in front of a jury. You've never had to present evidence for days at a time and sort of try to gauge, is this working with the jury or is it not working with the jury? You've never done any of that. So when you tell me, I think your risk is this, and I think we might be settled for this, and our chance of winning is that, I'm always very skeptical of that if you've never actually tried a case.
Right. And you mentioned before, let's talk about this, because I felt like this when I was practicing, death by lawyer. And I felt terrible. I felt like I was killing my client through the fees. And the other side just knew it. Those plaintiffs' attorneys just knew it. And you mentioned, do you think that contributes to not going to trial? Is it just not feasible under those rates?
It's excuse me. Well, so yeah, I mean, that is a problem. And trial prep, one of the things that I don't think I ever understood until I actually had to get ready for trial is the level of intensiveness for preparing for trial. Even a relatively small trial, it's like nothing else that I know of.
And it's always more than you think it's going to be. It's just weeks of your life.
It's like pulling a string on a sweater, right? You're like, oh, I'm just going to do this one thing. And then 3 days later, you're still doing that thing. You're like, when is this going to end?
Yeah.
But so, I mean, it's definitely hard to do, and it's expensive. But yeah, I mean, it does make it so you can't try cases. And one of the things I think that a lot of clients who use BigLaw don't think about, and what you hear a lot from clients who use BigLaw, exclusively use BigLaw, is, well, I use them because, the risk of losing is too great. If I have to go to trial, I know I need the best. And I'm like,
yeah.
Well, you understand that the rates that you're paying virtually guarantee you can't go to trial.
Right.
I mean, you can't afford it because, I mean, you'll have a case that's, you have $5 million in controversy, and it's not at all unusual you've already spent now. I've spent $2.5 million getting ready for trial. Mm-hmm. And now your lawyers will come to you and go, hey, trial's in a month. We're going to have to get ready. That means we're going to put in another $1.5 million worth of work getting ready for and trying the case. And suddenly you're like, wait a minute, I'm now paying more to just get to trial of this case than I would have paid to just settle the thing.
Yeah.
What is the point of this? Why am I spending so much money? And I'm still going to have that risk. There's still that risk that I'm going to lose. So, when you get those high-priced lawyers, and I think the plaintiff's bar knows this, when you have those really high-priced lawyers and you're saying we're going to trial, I think the plaintiff's bar starts looking at shops. You're like, you're not going to trial. You're going to spend a lot of money, and then I'm going to be able to make a settlement offer that's more than I would have otherwise, and you're going to find it attractive because of how much you've already spent and how much you're looking at spending going forward.
Right. Add that onto the top that maybe the other side secretly doesn't want to go to trial because no one likes it. Like, did you like trial? Let's be real. I found some people that truly did. I think 90% of litigation attorneys don't want to go.
So I liked the first one. That was a lot of fun. And there were parts that the other cases. I mean, there are fun parts about it. I mean, I really loved closing argument. I loved opening argument, not so much. Closing argument I love because closing argument is your chance, right? You watch those TV shows. If you're like me, you watch TV shows with lawyers in it, and you're like, none of that stuff really happens. They don't get to stand up and walk around and approach the witness. That doesn't happen. But I mean, for me, closing argument is the only thing that really comes close to that sort of TV lawyer experience. Mm-hmm. That's your chance to really be dramatic and really sort of spin a story. So I liked closing argument. But yeah, I mean, cross-examining witnesses is the most brutal thing. And directing witnesses, that's just it's so tedious and difficult. Mm-hmm. And not only is it that, but you're losing the jury. I mean, you'll be sitting there and you'll be going, they're not listening to any of this. And I've still got 8 pages of my outline left. And what am I going to do? I mean, I can't not ask these questions, but the jury's completely zoned out. They're thinking about lunch. And, so, I mean, there are parts about it I liked. I started doing a lot more appellate work before I left private practice. Appellate work I loved a lot more. It was what I found was appellate work really is all the things that I thought a lawyer would be. Like really digging into the law and seeing if you can find that creative argument. I really enjoyed that. But no, trial is just a slog. And I know people who love it too. I know plaintiffs lawyers who love it, and they take a completely different approach to it than defense laws and big law firms do. Their approach really is, you know what? I'm just going to throw some stuff against the wall. And we'll see what works. And if it doesn't work, that's fine. I'm just going to have a good time. And they seem to enjoy it a lot more.
Is there any way for the defense bar to take more of that attitude, or is that just impossible?
I wish we could. And I think, what I would love is one of the things is interesting. We actually, in the bills that I've been reviewing recently for some of our litigation, we've had a lot of substantial counterclaims, not just defensive counterclaims, but actually real counterclaims. Right. So we will get sued and we will have an actual real counterclaim. Mm-hmm. And so the law firm, one of the law firms split the bills. And so they were doing defensive work and offensive work. And I got two separate bills. And one of the things I noticed, which it kind of just verified what I already knew, on the defensive bills, they were just, I mean, incredibly exhaustive and exhausting. Like everything you could possibly do, right? Everything. I got to look at this 100 different ways, and I got to do lots of research on this. And then you look at on the offensive side, the plaintiff side, and it'd be like it's less than a third of the work. And I'm like, it's the same case, it's the same facts. But the answer is, I mean, I really think that it's that the risk of loss for defendants creates this paranoia and anxiety that if we lose, it's going to be a huge amount of money, right? But if you're the plaintiff, you're like, okay, I mean, I want to win. It would be great to win, but if I don't win, all that means is that I've wasted time. I've spent time on this case that I'm never going to get back. But nobody's going to lose their job. It's not going to be. Nobody's going to go bankrupt. It's just going to be something where I didn't get something I thought I should have gotten. I think it would be useful if the defense bar would sort of, or defendants would sort of cultivate that mindset, right? I mean, and it depends what it's like. If it really is bet the company litigation,
right,
I understand.
The company, of course, right?
Right. Yeah. But if you're a multi-billion-dollar company and you've got a case and plaintiff's best day is $20 million, right. Yeah, that's not even material.
Yeah, exactly.
So why are you paying somebody these really high rates to spend huge numbers of hours to avoid? Like, why don't you just relax? Don't exhaustively answer the discovery. Don't cover every single. I mean, if you read plaintiff's discovery, when they send their discovery responses back, I mean, it's clear they really aren't trying. They're like, exactly. I'm going to give you the basics. And if it's not good enough for you, fine, we'll go talk to the judge about it. But until then, this is good enough.
Yeah, exactly. No, 100%. And then the associate on the defense side is spending 100 hours on objections that the court's not even going to really parse through anyway.
Well, but I mean, that sort of goes back what we talked about in the first place. I mean, and I can't imagine what the pressure is like. I mean, I can't imagine what it's like to get out of law school and be making $225,000. But I just did a calculation before we started. If adjusted for inflation, what I started at as an associate would be $104,000 a year. Okay. And that was hugely controversial. The firm was like, "This is a ridiculous amount of money that we're paying you all," and and I can't even imagine what it's like to be an associate making $225,000 a year. I can't imagine what the pressure to bill is like. I can't imagine what it's the pressure to try to find justifications for that billing is like. I mean, but that's the problem. I mean, when you're making this much money, then there's a huge amount of pressure for you to justify it, and you have to justify it by doing things like, oh, hey, I know that I've read and rewritten the brief 8 times already, but maybe a 9th time, maybe this will be. And the reality is no. That 9th time isn't going to make a difference. You're not going to win on the 9th review. Right. You've done enough. But as long as you can get a client to pay for it, as long as the time is available for you to bill it, you will bill it. Right.
Okay. So well, I want to talk about some solutions. You might weave them in. You've already talked about some. What about price inelasticity? I thought that was a fascinating post that you did after we met, just because I'm a business major and it was really nerdy. I was like, wow, he's using an economic term. So what is price inelasticity?
Yeah. You can thank my love of the Planet Money podcast for me knowing those things. But I mean, the idea of price inelasticity is that as inputs go, there are inputs into the cost of the good or the service, and those go up and down. And in an inelastic price situation, that means that you can't change the price, right? Or there's a limited amount of price change you can do. So if you're selling an item and it's mostly you mostly sell to middle income customers, for example, you can't suddenly become a luxury priced item. That's not going to work. You're going to lose all your customer base. So you've got to go, okay, well, all right, maybe I'll adjust my profit margin down, or or I'll have to find cheaper suppliers, or I'll do less advertising. But you have to do things because you're limited in the amount of changes you can do to your price and still keep your market. part of the problem with law firms is that they don't have, a lot of the big law firms, they don't have those pressures because their customers, their clients really believe they must hire BigLaw. And if I don't hire BigLaw, I'm doing the wrong thing. And so they can feel free to do things like, initiate, hey, look, all the prices are, all the rates are going up 18% this year. And lots of clients would just go, oh, well, I guess that's what it's going to be.
So let me ask you, if you can't raise prices, what do you have to do to maintain profitability?
Well, what's funny is you have to do what law firms have been doing for years anyway, which is you have to do things like find new efficiencies, lower the number, use technology to take up jobs that used to be done by people. And law firms have been doing that for decades. The entire time I have been an observer for the last 20 some years, watching the way law firms have progressively and aggressively downsized their costs. But they never, ever pass those on to clients. At no point in my entire career have law firms ever said, hey, you know what? We used to have only 2 to 3 attorneys on a secretary. Now we're at 7 on a secretary. We're lowering our rates because now the rates still continue to go up.
Rates keep going up.
So, and they can do that because their clients feel that they have no other choice. This is who I have to go with. I have to go with the AmLaw 5 firm because if I don't and things go badly, I will be blamed for not picking a giant law firm. And so that's where this issue comes in, where there's no the bargaining power. If consumers give up their bargaining power, then the people who provide services to those consumers will take advantage and they will raise their prices. And that's what's going on, I think, in BigLaw. Not just BigLaw. I think there's a lot of it going on even in middle-sized, medium-sized law firms. But until clients start to realize, hey, I don't have to put up with this. There's another law firm out there that I can find that will give me good rates, that will give me the service that I need. But until that happens, there's not any incentive for firms to change.
Okay. So is that your main solution, recommendation, is really just spread the word about clients being vocal, just really make this a consideration. Don't just hire the firm and say, so what, and pass it on. Yeah. I mean, what are your thoughts?
Well, I mean, I think a lot of people don't understand the way law works. Even in-house lawyers, I think, don't understand the way law firms work. And so that's one of the things I'm really trying to do, and is explain, this is the way this really works. This is the way this market really runs. The idea that, for instance, on a post I wrote a couple of days ago, if you have the only partner in the world who specializes in llama import and export law, that's probably the guy you got to go with, right? Exactly. You've got to hire that person. Yeah. But if you have any sort of standard, regular legal needs, there's somebody who can provide that for you, aside from the person you're currently using. If the person you're currently using is making you happy, great, no problems. But if that person isn't making you happy, or that firm isn't making you happy, go shopping for someone else. You'd be surprised. One of the things you'd be surprised, I think a lot of people I talk to in-house are surprised on how often firms get changed. Not only like in between matters, but in the middle of matters, clients will change firms. They just feel like, look, I'm not happy with what's going on, and I went and talked to this other lawyer over here. I like him better. I want you to send the file. That happens a lot. You have the right to do that. But if you don't understand that you have the right to do that, then you really do feel locked in. Like, I've just got to go with this. I can't change horses midstream. Now, if you're not happy, if the services you're getting are not acceptable, if the price you're paying isn't worth what you're getting out of it, it's time to change.
What if that relationship was handed to you, and you're like, let's say it's someone that works for Brent, and this is your firm, Brent. What do you do then? Should they come to you with some recommendations and thoughts and be open about it?
Well, so yeah, I mean, and I can tell you that I've been in that situation. And it's difficult, and that's one of the things that I think is interesting about the practice of law, which is both good and bad, it is very much relationship driven. A lot of people, right? Most companies don't have any issue at all with changing vendors on things like, office supplies.
IT.
Whatever. Right.
Yeah.
Fine. I'll just find somebody else. But a lot of people find their lawyers or hire their lawyers because this is a guy I went to law school with, or this is somebody that I used to work at another firm with, or I used to work in-house with. And so that's a relationship, and they feel like they can trust that person. And I understand that, and I've done that too. And I've had good experiences with people that I've hired that way. But the fact that you have a connection, a personal relationship with that person doesn't mean that shouldn't be carte blanche for that person to take advantage. And so you really need to be willing to look and see. You need to be willing to manage your firms. That's another thing a lot of people don't want to do because it's hard. It's hard to review those bills. It's hard to dig into what's actually happened in that case. What have we actually accomplished? Are you really looking out for me, or are you just taking me for granted because I've been your client for 12 years? Those things are hard, and you have to do those because you have an internal client, and you're supposed to look out for your internal client's business. And so even if it's hard, even if it means you might lose a friend, or you might have to say some things you don't want to say to your friend, you have a job, and your job is to protect your internal client and to protect their business. And so you have to be willing to honestly assess what they do. You have to be willing to say, look, I think you're great. I love all the things we've done together, but I just can't continue this relationship. It's too costly. Or, maybe the cost is fine, but you just taking your response time is just way too long. And you're leaving me having to wait days and weeks for things that should have taken you hours. I just can't do this anymore. But the other thing, hey, talk to your lawyer first. That's it. And that's it. It's really hard. And I think because lawyers are intimidating, I think it's sometimes hard to have that conversation. To pick up the phone and say, hey, look, I'm not happy with what I'm getting. We need to talk about, you need to fix it, because if you can't fix it, then I'm going to have to go somewhere else. Right. And that's also hard to do. It's hard to talk to lawyers, especially litigators, I think, because we tend to be a little aggressive and confrontational. But I mean, that's something you have to be willing to do. And if you can't do it, then you need to find somebody who can do it for you.
Yeah. Fantastic advice. Well, I could talk to you literally all day. I know we spoke longer than this when we first touched base on the phone, but I want to give you just one last final say. So is there something you want to add? Is there any message you want to get there? Or is there anything you need maybe that we could all help you with?
I mean, I guess the one thing that I think really I want lawyers to think about, all lawyers, in-house lawyers and law firm lawyers, is I really do want us to start to think about the fact that we're business people and we're running businesses. And it is frustrating to me when I see what law firms do that don't make any business sense. And I see it quite a bit, right? You see, I'm like, that doesn't make business sense. Why are you doing that? Why are you jacking up associate starting salaries to $225,000 an hour? Why are you doing that? But I see it in-house too. And I think a lot of that is because in-house people sort of come from law firms, or tend to come from law firms, or they look at law firms as sort of their model. And it's the same thing. Run your in-house department like a business department, right? Don't choose vendors based on who you like, who's your buddy. That's great if you can find somebody who's your buddy who can do something for you, great. But if you can't find that person, or the person that you start with isn't doing what they should be doing, you have to make a business decision. Don't make a decision based on what you think law firms would do or how the law is. It's a business. We're all business people. We need to think about this like a business, run what we do like a business.
Okay. Brent, thank you for those wise words. This whole interview was fantastic. I really appreciate your time today.